All right, good afternoon. This is the criminal docket of the 294th District Court. And bailiff, who do we have ready this afternoon?
Your Honor, we've got Mr. Michael Covey with Mr. Kurt Knoll.
Afternoon, Judge.
Good afternoon, Mr. Knoll. How are you doing today?
Good.
All right, court calls CR 20-327, State versus Michael Shane Covey. We're set for arraignment today. Is that correct, Mr. Knoll?
It is, Judge. Mr. Covey and I have reviewed his indictment. The case that we're here on today is the possession of a controlled substance, penalty group 1, less than a gram. His name is spelled correctly. For the purposes of arraignment, we would be entering a plea of not guilty. I have requested, although I don't have it quite yet, the discovery through the portal. I actually do already have a plea offer to deferred. I think the fine was $2,500. Subsequent to this offense, he's been arrested on a misdemeanor offense, but we'll deal with that, I think, at another time. I believe it to be a misdemeanor.
Okay. And maybe I missed it. Did you go over the indictment with him? Is his name spelled correctly?
His name is spelled correctly, and yes, we've reviewed the indictment. He understands the charge.
And his plea?
Not guilty.
All right, the court will enter Mr. Covey's plea of not guilty into the record. Court will set Mr. Covey then for a pretrial hearing. And do you know when you're available in February, Mr. Knoll, or are you already over here on certain dates in February?
Judge, I actually don't recall. Just said it. I'll be here.
Okay. That makes it easy. How about today is the 5th? How about February 23rd?
Sounds good to me.
All right. We set pretrial on that date.
And Judge, just for the record and for Mr. Knoll's information, it appears that that paper discovery was sent to the portal earlier today. Of course, discs will still need to be procured the same way, but the paper discovery is on the portal now.
Okay.
And
I'll pick up the discs on my way out today.
sounds good, Mr. Knoll. All right. Thank you, Mr. Covey. We'll see you back on the 23rd.
Yes, sir. Thank you, Your Honor.
You're welcome.
And Your Honor, it's going to be just a couple minutes before our next defendant arrives.
Yes, ma'am. Thank you.
Yes, sir.
You done with this, Mr. Knoll? I'll make a motion.
So, probably not.
All right, Mr. Knoll, is this Mr. Gutierrez?
It is, Your Honor.
All right. I'll show that you have filed a writ seeking bond reduction. Is that correct?
That's correct, Judge.
Are you going to call your client to testify today?
Briefly on the issue of bond, yes, Your Honor.
Mr. Gutierrez, if you will, raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Mr. Gutierrez, during your testimony today, make sure that you don't talk over Mr. Knoll, and he's going to do the same so that my court reporter can take down everything that's being said in court today. Understand?
Yes, sir.
All right, thank you. Go ahead, Mr. Knoll.
Thank you, Judge. Mr. Gutierrez, would you please state your full name?
Jesus Humberto Gutierrez.
And you've been indicted, you understand, on an aggravated assault, is that correct?
Yes, sir.
Do you have any other prior convictions, any other prior felony convictions in Texas or any other state?
No, sir.
I believe the bond is currently set at $150,000, is that correct?
Yes, sir.
Assuming that a bondsman would want at least 10% down, do you have $15,000?
No, no, sir. I'm sorry.
You have $15,000 that you could pay a bondsman to make that bond.
No, sir.
If the court were to reduce the bond, and our requested amount is $20,000, do you think you would come closer to being able to make that bond?
The 10% of that bond, or
10% of $20,000 being $2,000.
yes, sir.
You have family that might be able to help you with that.
Yes, sir.
Do you presently own any real estate?
No, sir.
Do you own an automobile?
No, sir.
Have any money in the bank?
Yes, sir.
How much in the bank?
I got 5,000 in my bank. 500 my bad.
500?
Yes, sir.
Okay. Do you have any money that anybody owes you?
No, sir.
Do you have a paycheck or anything like that that is owed to you?
No, sir. I believe my next stimulus is coming in on the 18th. They said, which is 600.
I don't know.
So
So you might have
1,000.
$1,100 on the 18th of this month.
Yes, sir.
Are you asking then the court to reduce the bond to that figure?
Yes, sir.
Because that's all we have.
Ms. Heisel, any questions for Mr. Gutierrez?
Yes, Your Honor, briefly. Mr. Gutierrez, do you know what you're currently charged with?
I understand what I'm being charged with this now.
Okay, so you understand that it's aggravated assault with a deadly weapon?
Yes, ma'am.
Have you ever been arrested for any violent offenses before this?
No, ma'am.
Okay, so you, in 2016, when you were a juvenile, you were not also arrested for aggravated assault with a deadly weapon?
No, no, ma'am.
Okay. Mr. Gutierrez, have you actually spoken with any bond companies here in Van Zandt County regarding making bail with them?
Yes, ma'am. I talked to East Texas Bail Bonds. I haven't discussed about my bond because it's too high. But now that it's getting reducted, I'm going to the same person, East Texas Bail Bonds.
Okay, so you did talk to them about making a bond at the lower amount, but not at the higher amount. Is that correct?
Yes, ma'am.
Okay. Your Honor, no further questions for this witness.
Mr. Knoll, any additional questions of this witness?
No, Your Honor.
All right, based on the evidence before the court will find that based on Mr. Gutierrez's financial ability and perhaps lack thereof, court finds that $150,000 is excessive. At this time, court will lower the recommended bail in this case to $35,000 with associated conditions of pretrial release as previously ordered. If none have been ordered, then the court will order conditions of pretrial release that will require him to report to a pretrial release officer, avoid any harmful substances, avoid committing any additional offenses against the criminal laws of this state or any other state or the United States, and require him to reimburse any court-appointed indigent counsel that's been appointed. And Mr. Knoll, you have been appointed, is that correct?
That's correct, Judge, on this case.
Okay. And Mr. Knoll, did you file a proposed order with your writ?
Judge, I think there should be one. There normally is. I don't know that I have a copy.
Did you e-file it though?
Yes,
Okay.
it would have been.
If you e-filed it, then I will find it in the clerk's office and print it out and sign it.
Thank you, Judge.
You're welcome.
That's all I have. May I be excused?
Yes. All right. So let's see. Is Mr. Gutierrez set already on any other docket?
Judge, I don't know if he's set next week or not. I actually don't recall.
Well, let's take a moment. We'll determine that.
He said on, oh, that was the first one. I have several cases set next week. I don't recall if his is.
Show Mr. Gutierrez to be set for docket call on January 26th at 1:30. So this case already having been set for docket call, then will be adjourned in this matter.
Thank you, Judge.
Thank you, Mr. Knoll.
Come on, sir.
Mr. Gimbel, is this Mr. Hansard?
No, Your Honor, I filed a waiver of arraignment on Mr. Hansard.
Okay, well, let's go ahead and note that for the record. CR 20339, State versus Norman Wayne Hansard was set for arraignment today. The court has approved the waiver of arraignment and has set pretrial in that matter on February 11th. So who do you have with you? Is this Mr. Thomason?
Yes, it is, Your Honor.
All right, court call CR 20313-314, State versus James Matthew Thomason. We're set for pretrial today.
Yes, we are, Judge. We have we have all the discovery matters in his issue, and we have no pretrial issues at this time. However, we have not received a plea offer at this time.
State, do you know if the state, Ms. Heisel, do you know if the state intends to make a plea offer in this case?
Yes, Your Honor. I believe this is Mr. Woodwike's case, and I know that him and Mr. Gimbel were emailing about it, so I'll follow up with him just to make sure that that has been handled.
Thank you, Ms. Heisel. All right, the court will set Mr. Thomason. Are you available on February 23rd, Mr. Gimbel?
Yes, I am, Your Honor.
All right, the court will set Mr. Thomason then for docket call on February 23rd, and the court would hope to have a plea offer, if one's going to be made to the defendant well in advance of that time, so Mr. Thomason can decide whether he would like to accept, reject, or counter offer that. And then Mr. Gimbel, the court would like to have some type of announcement on the 23rd as to proposed disposition, if any, in this case.
Yes, Your Honor.
All right, it being set for February 23rd, Mr. Thomason, if you make bail in this case, then you are due in this court at 9 a.m. on that date unless otherwise ordered.
Yes, sir.
All right.
Your Honor, Judge Martin.
Yes, ma'am.
You're fixing to hear a plea for Miss Keisha Everett. I sent you some communication. I just want you to be aware of before she steps up here.
Okay, thank you. I'll check that. All right, Ms. Heisel and Mr. Gimbel, do we know if the court-appointed attorney fees for this case have been reflected in the judgment? I believe right now they're showing to be zero. Zero court cost, zero fine, zero reimbursement fee. But I believe that Mr. Gimbel will be entitled to $500. Is that part of the agreement to waive those?
I don't believe so, Your Honor. I mean, unless Mr. Gimbel wants to waive those, I believe that we will need Ms. Abney to correct that. And there should also be court costs as well. So I will get with her and figure out what the issue is if you would recall that case.
Yes, ma'am, we'll do. All right, Ms. Everett, if you will, we've got to make some changes to your paperwork. If you will, just have a seat and do whatever the bailiff directs you to do, and we'll call you back up in a moment, okay?
Yes, Your Honor.
Thank you.
Everett, just have a seat right here.
I apologize, Judge, for my failure to catch that.
Okay, that's what I got my bailiff for. She's on top of it. Good afternoon, Mr. Claybrew. How are you, sir?
I'm fine, Your Honor. How are you, sir?
I'm moment to moment, it seems. How do any of us know how we're doing until it happens to us, right? All right, this is cause number CR 1777, State versus Jerry Anthony. And this is a hearing on Mr. Anthony's motion to revoke. Is that correct, Mr. Claybrew?
Yes, Your Honor.
All right, what announcement do you have for the court?
Judge, I believe this is our first setting. We'd ask court to set this for a pre-trial at a time that is convenient. And I haven't spoken, Madam Prosecutor, but nor do I have all the discovery I feel like may be associated with this case.
And Your Honor, the state just made an offer to Mr. Calabria yesterday. I will check the portal because it's an MTR. I'm not sure that the attorney of record has been changed over, so I'll make sure that's all ironed out. We did make an offer yesterday, so we would not be opposed to any reset.
Thank you, Ms. Heisel. Okay, Mr. Calabria, what I would do is I would set this for another hearing on the motion to revoke on February 23rd, unless you have any scheduling issues on that date.
23rd is fine, Your Honor.
23rd, okay.
Yes, sir.
All right, Mr. Anthony, you will sign that notice of appearance. Mr. Claybrew, if you do not have a notice of appearance, check with the bailiff. There you go. Have Mr. Anthony sign that. Court will get the white copy and Mr. Anthony will get the yellow copy. And we'll set that MTA hearing on February 23rd. And that will be at 9 a.m.
Is it an MTA hearing, Your Honor, or an MTR hearing?
Well,
Adjudicator? Or
honestly, I'm not sure. Mine says MTR. I can check just a moment. It appears to be a motion to adjudicate, Mr. Claybrew.
Thank you.
All right, once you sign that, Mr. Anthony, and you receive your copy, then you'll be free to go. I do want to remind you, sir, that you are still on community supervision. You're still required to report and pay and do all the things that the court had previously ordered you to do. Do you understand?
Yes, sir.
I think the worst thing that you can do for yourself and for Mr. Calabria trying to help you is to rack up any more violations on your community supervision. So if you fail to report, fail to pay, fail to do anything that you're directed to do by your probation officer under those terms and conditions, could result in them filing additional charges against you in an amended motion to adjudicate. You understand?
Yes, sir.
Okay. All right. Once you get your notice, then you'll be free to go, and we'll see you back on February 23rd at 9 a.m. in the courthouse, unless you're given different directions by your attorney or the court.
Yes, sir.
And Mr. Claybrew, I'll go ahead and give you a heads up that unless things change between now and the end of February, there's a really good chance that everyone's going to be appearing via Zoom, and we may not be able to appear in the courtroom unless there's going to be a disposition to the case that requires fingerprinting or something of that nature. So you may want to speak with your client about his ability to appear via Zoom if there is no disposition on the 23rd. And you'll receive more information from the court next week on what the court's being required to do by the Office of Court Administration and the Texas Supreme Court. Okay.
I understand, Your Honor. Thank you.
Thank you, Mr. Claybrew.
That excuse.
Yes, sir.
Judge, I have additional information on Miss Everett's plea for the court. Miss Everett shows a zero balance for her fine and court costs because she's already paid those in full. And the attorney's fees are not on the judgment because she is signing for time. So it's our understanding that that should be submitted via pay sheet instead of on the judgment.
Okay, great. So she's going to TDC?
Yes,
Or-
sir.
Excellent. Okay. And Ms. Heisel, while we're waiting for, can you go ahead and give me the terms on Ms. Everett's plea?
Yes, Your Honor. It's for 3 years in the Texas Department of Criminal Justice. Like I said, she's paid up on all of her money. She's going to have 161 days time credit towards that 3 years. And I believe that's it, Your Honor. Pleading true to each of the state's allegations, Your Honor.
And just because I'm not seeing the judgment, I don't have the case pulled up, what's the level of offense?
Your Honor, I believe it's, let me make sure I've got it correct. Yes, it is a 3rd degree prohibited substance in a correctional facility.
All right, thank you. All right, good afternoon, Mr. Manning.
Good afternoon, Judge.
Is this Mr. Zimmerman?
That's correct, Judge.
All right, court call CR 20-374-375, State versus Michael Cody Zimmerman. Believe we're set for arraignment today, is that correct?
That's correct, Judge. I've discussed the arraignment, or discussed the indictments with my client. We've gone over those. His name is spelled correctly. And this time, Judge, we're entering a plea of not guilty on his behalf.
All right, court will enter Mr. Zimmerman's plea of not guilty into the record, and we will set pre-trial in this matter. I'm going to set this one out a little bit further. Looking at the nature of the offense, I'm assuming there may be a considerable amount of evidence for you to review.
Judge, I have gotten the written evidence and reviewed that. Had the opportunity to talk to my client about that as well. We're still waiting on, I haven't picked up the audio-visual evidence at this time, so I don't know how much of that there is.
Are you available on March 9th, Mr. Manning?
Yes, Judge.
All right, the court will set Mr. Zimmerman then for pretrial on March 9th. In each cause.
State or pretrial. Yeah. Judge, may we be excused?
Yes, we'll see you back on March 9th, Mr. Zimmerman. If Mr. Zimmerman, for some reason you bond out, post bond in this case, you'll be due to report to the court in person on March 9th at 9 a.m. unless you're otherwise instructed by your attorney or the court. All right?
Thank you, Judge.
Thank you, Mr. Manning.
Oh, they're not. Okay. Did he tell you what? Yeah. Okay.
You got no instructions.
I'm sorry. In my preparations for being over here, I failed to bring them in an ink pad to take the thumbprint. I ran back there thinking I had something, I didn't, and that, as you can see, hasn't been used, but it was set up, so one of the deputies would dump it. That'll do though. I'm sorry. Did you hear Courtney Powers in it? Okay, no hurry, this one's gonna take a few minutes. All right, Ms. Powers, you have a seat right there, please. Okay. Ms. Everett, go on and stand up now.
All right, Ms. Everett, if you will, raise your right hand. I'm going to place you under oath. Ms. Everett, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
All right, thank you. You can put your hand down. Just one moment. I'm going to pull up your case. All right, Ms. Everett, you appeared before the court on March 29th of 2018, and you pled guilty to the offense of prohibited substance in a correctional facility. That is a third-degree felony offense that carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice Institutional Division, and a fine not to exceed $10,000. On that date, the court heard the evidence and found that there was enough evidence to convict you of the offense. However, the court deferred a finding of guilt, means the court did not convict you. However, the court did place you on community supervision for a period of 3 years, and the court also assessed a $2,000 fine. It was during that term of 3 years that the state filed a motion to adjudicate your guilt and to request the revocation of your community supervision. Have you had an opportunity to review the state's motion with your attorney, Mr. Gimble?
Yes, Your Honor.
Do you feel like you had enough time to talk with him about your case and have all of your legal questions answered?
Yes, Your Honor.
And Mr. Gimble, is my understanding that your client intends to plead true to all counts in exchange for the state's recommendation?
That's correct, Your Honor.
And does your client waive the formal reading of the state's motion to adjudicate at this time?
Yes, she does, Judge.
All right, Ms. Everett, I'm going to ask you, and I'll tell you what I'm going to do. I'm going to display the state's motion to adjudicate on the screen in just a moment. So, Ms. Everett, I'm going to ask you, how do you plead to counts 1, count 2, count 3, count 4, count 5, count 6, count 7, count 8? How do you plead to those counts? Are those counts true or not true?
True, Your Honor.
And Ms. Everett, are you pleading true to those because they are true?
Yes, sir.
And has anyone threatened you, forced you, or pressured you to make you feel like you had to plead true to those counts?
No, sir.
And are you pleased with Mr. Gimbel's representation of you?
Yes, Your Honor.
Okay. All right, the court will accept Ms. Everett's plea of true to all counts contained in the state's motion. Mr. Gimbel, is there any objection to the offer of the defendant's waiver of rights and plea of true to the state's motion to adjudicate as State's Exhibit A?
No objection, Your Honor.
All right, the court will admit State's Exhibit A and takes judicial notice of Ms. Everett's judicial confession. Is there anything further from the state?
No, Your Honor. We rest and close.
Anything further from the defense?
Nothing further, Your Honor. We rest.
All right, then based on the evidence before the court will find that the defendant has violated the terms and conditions of her community supervision. Court finds counts 1 through 8 to be true. The court hereby adjudicates the guilt of Ms. Everett and convicts her of the 3rd-degree felony offense of prohibited substance or item in a correctional facility. The court will follow the plea agreement between the defendant and the state. The court hereby revokes the community supervision of the defendant and assesses her punishment at 3 years confinement in the Texas Department of Criminal Justice Institutional Division, finds that Ms. Everett has satisfied the payment of all her financial obligations. Court hereby orders Ms. Everett to receive credit for days spent in jail on this charge in the amount of 161 days. Ms. Everett, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence.
Yes, Your Honor.
Thank you. I'm gonna have you step to your left to be fingerprinted by the bailiff. Good luck to you.
Thank you.
You're welcome.
Your Honor, that's all I have this afternoon. May I be excused?
Yes, sir. Thank you, Mr. Gimbel. Good to see you.
Thank you, Mr. Gimbel. Ms. Powers, if you'd like to say this party.
Good afternoon, Mr. Schmidt. How are you, sir?
Hey, Judge.
Is this Ms. Courtney Powers?
It is.
All right, court calls CR 17-165, State versus Courtney Lynn Powers. I believe we're set for docket call today. Is that correct?
We are, Judge. We're prepared to enter a plea.
Okay, can you tell me the terms?
Judge, it's a motion to adjudicate on a 2nd-degree possession, penalty group 1, 4-200. The agreed upon terms are that Ms. Powers' community supervision be revoked. Should be adjudicated guilty and sentenced to 3 years in Texas Department of Criminal Justice or to pay the balance of her financial obligations. She does, Judge. She has 689 days credit time.
689?
That's correct.
And that was PCS, penalty group 1, 4-2?
That's correct, Judge.
All right, just one moment. Let me pull up her case. Ms. Heisel, is the motion that the state is proceeding on, is this the motion filed on May 14th of 2019? Is that the correct motion?
Yes, Your Honor.
Okay. All right, Ms. Powers, if you will raise your right hand, I'll place you under oath. Ms. Powers, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Ms. Powers, are you pleased with Mr. Richard Schmidt's representation of you?
Yes, sir.
You feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you signed today with Mr. Schmidt there in the jail court that you do not understand?
No, sir.
Throughout the documentation, if your signature is in there, does that mean that you have signed those documents only after reading them and understanding them, and that you have put down your true and correct signature?
Yes, sir.
Okay. Ms. Powers, you appeared before the court on October 10th of 2017, and the court heard your plea of guilty to the second-degree felony offense of possession of a controlled substance in penalty group 1, 4 grams to 200 grams. The court, after hearing the evidence, found that there was enough evidence to convict you and adjudicate you. However, the court did not. Rather, it deferred a finding of guilt and placed you on community supervision for a period of 5 years. It was during this period of 5 years that the state filed this motion to adjudicate your guilt and to revoke your community supervision. You've reviewed this document with your attorney, have you not?
Yes, sir.
So I'm going to ask you at this time, how do you plead to counts 1, 2, 3? How do you plead?
Or true.
Okay. And Mr. Schmidt, does your client waive the formal reading of all those counts?
We do, Judge.
All right. Then the court, let me ask you, Ms. Powers, in your pleading true to counts 1, 2, and 3, are you pleading true to those counts because those counts are true and for no other reason?
Yes, sir.
Has anyone threatened you, forced you, or pressured you, Ms. Powers, to make you believe that you had to plead true to those counts?
No, sir.
All right. The court will accept Ms. Powers' plea of true to counts 1, 2, and 3. Mr. Schmidt, any objection to State's Exhibit A, the offer of the defendant's waiver of rights and plea of true?
No objection, Judge.
Court admits State's Exhibit A and takes judicial notice of Ms. Powers' pleas of true. Is there anything further from the state,
No, Your Honor, we rest and close.
from the defense?
Nothing further, Judge. No.
All right, then based upon the evidence before the court will find that Ms. Powers has violated the terms and conditions of her community supervision. Court finds that her community supervision should be revoked, and the court will this day convict her of the second-degree felony offense of possession of controlled substance in penalty group 1, greater than or equal to 4 grams but less than 200 grams. The court will assess her sentence in compliance with the plea agreement reached between Ms. Powers and the state at 3 years confinement in the Texas Department of Criminal Justice Institutional Division. Will order Ms. Powers to pay the balance of her financial obligations, and the court hereby awards Ms. Powers 689 days credit for the time that she has spent in jail on this cause. Ms. Powers, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Good luck to you.
Thank you.
You're welcome.
Thank you, Judge. That's all I have.
Thank you, Mr. Bennett.
Thank you, sir. Thank you. Stop that. That's not very likely. You want to take these 2 lanes now? You got the double sergeant? Okay, he said I would get copies of that, or they can you guys. Thank you for sending that. Mr. Shannon, why don't you go ahead and slip on the floor, ma'am? Ma'am. That seat right there.
Who do we have, bailiff?
This is Mr. Shannon, sir, for Mr. Adams. Do you have him yet in the?
I do. We'll bring him in at this time. Good afternoon, Mr. Adams.
Good afternoon, Your Honor.
All right, we have Mr. Shannon available at this time. This is cause number CR 20363 and 364, State versus Roseman, Renee Shannon. I believe that we're set for arraignment today. Are you ready for arraignment, Mr. Adams?
That's correct, Your Honor. We are, and I am ready to proceed. I visited with Mr. Shannon about this a couple of weeks ago, and Mr. Shannon advised me that he wanted to be formally arraigned on the record.
Okay. Give me just a moment and let me retrieve his case. All right, Ms. Heisel, I'm going to ask that you present the indictment to Mr. Shannon, and I've got it available here. Go ahead, Ms. Heisel.
All right, Your Honor. If you don't mind, I'm just going to read. Is this in cause number 363?
Yes, ma'am.
Okay. In the name and by authority of the state of Texas, comes now the grand jury for the for the county of Van Zant, state of Texas, duly impaneled, sworn, charged, and organized, January term 2020, upon their oaths in into said court at said term, that Rosamond Renee Shannon, hereinafter styled defendant, on or about October 23rd, 2019, and before the presentment of this indictment in the county and state aforesaid, did then and there intentionally, knowingly, and recklessly cause bodily injury to Cicely Nicole Laney, hereinafter styled the complainant, a person with whom the defendant has or has had a dating relationship as described by section 71.0021B of the Texas Family Code, by intentionally, knowingly, and recklessly impeding the normal breathing or circulation of the blood of the complainant by applying pressure to the throat or neck of the complainant against the peace and dignity of the state, signed this foreperson of the grand jury.
Mr. Adams, how does your client plead to the indictment in CR 2363?
Your Honor, Mr. Shannon enters a plea of not guilty to the indictment.
And is Mr. Shannon's name spelled correctly here?
Yes, sir.
Yes, sir, it is.
All right, thank you, Mr. Shannon.
You're welcome.
Court is going to now produce the indictment in cause number CR 2364. Just one moment. And while I'm doing that, Mr. Adams, have you explained the range of punishment to Mr. Shannon? And if so, does he understand the full range of punishment in that third-degree felony cause of assault of a family or household member by impeding breath or circulation?
I believe we've discussed that. Mr. Shannon, do you recall us talking about the maximum range of punishment for the third-degree felony?
Yes, sir. I think it's 599. Or no?
I think
The first charge, the felony one.
the
Mr. Shannon, I would tell you that in the indictment that Ms. Heisel just read, the charge is assault of a family or household member by impeding breath or circulation. That is a third-degree felony in the state of Texas and carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice Institutional Division, and also carries an optional fine not to exceed $10,000. Do you fully understand that range of punishment?
Yes, sir.
And you understand what you're being accused of?
Yes, sir.
All right, now in cause number CR 2364. Make sure I have this one. All right, the court, for the record, is having displayed on the screen indictment in cause number CR 2364 entitled State of Texas versus Rosamond Renee Shannon with a charge of aggravated assault with a deadly weapon, a second-degree felony. Ms. Heisel, if you will present this to the defendant, and remember that I have a court reporter here who she can type real fast, but she might not be as fast as you can read.
Yes, Your Honor.
All right, thank you.
In the name and by the authority of the state of Texas, the grand jury for the county of Van Zant, state of Texas, duly sworn and paneled. Sorry, Judge. I'm going to read off of my screen. I can see a little bit better. Duly selected and paneled, sworn, charged, and organized as such at the January term AD 2020 of the 294th Judicial District Court for said county, upon their oaths present in and to said court at said term, that Rosman Renee Shannon, hereinafter style defendant, on or about September 24th, 2020, and before the presentment of this indictment, in the county and state aforesaid, did then and there intentionally and knowingly threaten Cicely Nicole Lamy with imminent bodily injury by attempting to stab her, and did then and there use or exhibit a deadly weapon, namely a kitchen knife, during the commission of that assault against the peace and dignity of the state. Signed, the foreperson, the grand jury.
All right, and the record will reflect that the range of punishment for a second-degree felony offense of aggravated assault with a deadly weapon is confinement in the Texas Department of Criminal Justice Institutional Division for a period not less than 2 years or more than 20 years, and a fine not to exceed $10,000. Mr. Shannon, do you understand that range of punishment?
Yes, sir.
And Mr. Shannon, is your name spelled correctly in the indictment?
Yes, sir.
And Mr. Adams, how does your client wish to plead at this time?
Your Honor, Mr. Shannon's going to enter a plea of not guilty to the indictment.
Okay. And I would bring to your attention, Mr. Adams, if you had a question about during the presentment of the indictment, that the term of the grand jury from January of 2020 was extended by court order due to the pandemic, which is why the offense date is subsequent to the grand jury date, and what would typically maybe be outside the January term of 6 months. Just for the record and for your understanding, the court did extend the grand jury term to that of December 31st, 2020.
Understood, Your Honor. I suspected as much.
Okay. All right, so the court will enter Mr. Shannon's pleas of not guilty for each charge into the record, and we will now set this matter for pretrial. Any special requests on dates, Mr. Adams?
The more time the court could allow us, the better, Your Honor. The state hadn't been able to upload the discovery yet into its discovery portal. Last I checked, which I think was right after lunch. And so I don't know what I'm going to find there. If we have just a month from now, then that I would like to have more than the usual 4 to 6 weeks, just in case there is a substantial amount of documents and records for me to recover in deciding how to proceed at pretrial.
Ms. Heisel, do we know the status of any discovery for Mr. Adams?
Your Honor, I just sent the discovery to the portal. These do arise out of 2 different offense dates, even though they are the same victim, but I believe that there are some witnesses that Mr. Adams might want to contact based on my review of the discovery. So I have no objection to that longer date for him.
All right, the court will set pretrial, Mr. Adams, on March 9th, unless you have a conflict.
Nope, no conflicts, Your Honor.
All right, then each case will be set for pretrial on that date. And should Mr. Shannon make bail in the case, then on March 9th, he would be required to report to the court at 9 a.m.
Understood.
And Mr. Adams, I've been telling attorneys today that we know really not what our future holds with regards to our ability to conduct in-person proceedings, and which probably wouldn't affect you as much because you're accustomed, you're used to and accustomed to doing the Zoom hearings, but we may not be able to do in-person hearings. So if Mr. Shannon makes bail, you'll want to discuss with him the ability to access Zoom and technology to report to court and have a video conference hearing. If he's unable to do that, then you'll give that information to the court, and then we'll make the next step in determining whether or not we can conduct an in-person hearing. I plan on sending out more information to the bar next week once our COVID operation plan recertification plan is approved by the regional judge, it will have more information on what the court has to do before it can allow an in-person proceeding.
Understood. Thank you, Your Honor. And
All right.
I'll visit with Mr. Shannon between now and our pretrial date, of course, and remind him of those issues should he make bond between now and then.
Thank you, Mr. Adams. All right, Mr. Shannon, we'll see you back on March 9th, okay?
And Mr. Adams, Mr. Shannon has indicated to me that he does plan to get out of jail today.
Okay. Then, Mr. Shannon, if you'll note Judge Martin's remarks there, if and when you do leave the Van Zant County Jail, make sure that you contact me as soon as possible so that I know how to reach you and how to get in touch with you between now and our court date.
Yes, sir.
Okay, thank you.
Mr. Adams, is that all you have today?
Your Honor, I also have on the docket for arraignment Miss Amy Irene Davis. Now, she and I visited a couple of 3 weeks ago, and we talked about a waiver of arraignment. Now, she signed a waiver of arraignment, but I was visiting with another client either immediately before or after Miss Davis about the same matter, and I had Miss Davis sign the wrong waiver. And so I have not found myself back in the Van Zant County Jail since that time. And so we're happy to waive arraignment, I believe, but I because of my own inattention to detail, I didn't get a waiver filed prior to today.
It's okay. All right. Well, let's go ahead and we can arraign her quickly. All right. This is in cause number CR 20328, State versus Amy Irene Davis. And the court will have displayed on the screen the indictment and CR 20328. Ms. Davis, can you see that okay?
Yes, sir.
Okay. All right. I'm going to give you just a moment to read this, and then Mr. Adams will give you an opportunity to see if your client wants to waive the formal reading.
Ms. Davis, let me know when you've had enough time to read through it.
I've read it.
Okay. Are we ready? Are we on the record, Your Honor?
Have you read this prior to today, Ms. Davis?
Yes, sir. I have a copy.
Oh, you do. Excellent. Okay. Go ahead, Mr. Adams. I'm sorry.
Okay. Ms. Davis, you and I have discussed the charge that's pending against you, correct?
Yes.
Okay. And you've indicated that you've read the indictment prior to today. Is your name in the indictment properly spelled?
Yes.
Okay. Do you understand what you're accused of in the indictment?
Yes.
Okay. And Ms. Davis, is it your wish to enter a plea of not guilty to the indictment today?
Yes, sir.
Okay. And Ms. Davis, are you willing to waive the formal reading of the indictment on the record? In other words, are you willing to waive your right to have the state's attorney, Ms. Heisel, read that indictment on the record from start to finish?
Yes, sir.
Okay. Thank you.
All right. Thank you, Ms. Davis. The court, having heard the plea of not guilty, will enter that into the record, and the court will set Ms. Davis for pretrial. Are you available on February 23rd?
I am, Your Honor.
Do you know if you're over here on a different date that's more convenient for you, Mr. Adams, than that date? That's the date I'm looking at, but I have things prior to them, but I didn't want to put you under a time constraint. But oftentimes you know your schedule better than I do as to when you're going to be here and when you're not.
Your Honor, considering the circumstances, the 23rd would probably be the best date. I am over there prior to then on the 9th, but I don't think that's going to be enough time between now and then for me to comfortably be able to do what I need to do.
Okay. Then the court will set pretrial in this matter on February 23rd. Ms. Davis, if you get out of jail, if you post bail, then you need to stay in contact with Mr. Adams so he can direct you on how to report to court properly, okay?
Yes, sir.
Ms. Davis, you and I will be visiting between now and then.
Okay.
Make sure you-
Does that conclude your business, Mr. Adams?
That does it, Your Honor. May I be excused?
Yes, sir. Thank you very much. Appreciate it. Good to see you.
You all. Happy New Year.
Happy New Year.
Come on up here to the podium.
Is this Mr. Norris?
Yes, Your Honor.
All right, court call CR 17380, State versus James Cole Norris, hearing on Mr. Norris's motion to revoke. Mr. Norris, I had a note here that you're trying to retain an attorney, and my note says that you have indicated to my indigent defense coordinator that you have hired Mr. Daniel Hunt. Is that correct?
Yes, sir, but he doesn't have time to do me, to represent me, so I had to put in for a court appointed.
Have you tried to hire someone else other than Mr. Hunt?
No,
Do you have the financial ability to hire an attorney?
no, sir.
How was it that you were going to hire Mr. Hunt? If Mr. Hunt would have taken the case, would you have hired him?
Yes, sir.
Okay, so explain to me how you can hire one attorney, but you can't hire another attorney.
Years ago, I've hired him to represent me before. I thought I was under assumption that I had him under containment or retainer, and apparently that expired a year ago, and I wasn't aware of that.
Okay. And have you completed the application for court-appointed attorney?
Yes, sir.
When did you do that?
Last week, when I was aware, I was finally able to get word to my mom because she'd been trying to get a hold of him. Apparently, she finally did, and he told her that he wouldn't be able to do anything for me, and that I needed to put in for a court appointed.
Okay. All right. Well, do me a favor. Just have a seat, and I'll be back with you in just a moment. Okay.
Yes, sir.
Ms. Heisel, for the record, on cause number CR 2292, State versus Devin Scott Key. Mr. Key is represented by Mr. Files, and Mr. Files filed a waiver of arraignment, which was approved by the court, and pretrial has been set on February 11th.
Thank you, Your Honor.
You're welcome. Give me just one moment, and then we'll be back on the record with Mr. Norris.
Ms. Davis, you should go with my sergeant.
might get reinstated.
I'm sorry?
This is the information on my distribution.
Yes, sir. Yeah, this is our district judge appearing via Zoom to speak to you about that.
All right, Mr. Norris. All right, Mr. Norris, I don't have your paperwork at this time. I haven't seen it. My staff's going to look for it. If we can't find it, we may have the jail staff over there have you fill that out again. What I'm going to do is I'm going to set you for next week on Tuesday afternoon. And between now and then, someone will be with you. Either we'll find the paperwork and I'll review it. And I may, if you qualify, I may point you an attorney before then and you'll get information about that. However, if I find that you're not eligible, then we'll talk about that on the 12th. Okay. So either way, I'm going to see you on the 12th. Understand?
Yes, sir.
Okay.
Signature right here. Well, Mr. Norris, here's your copy. Just go ahead and see again, sir. You're up, sir. Your Honor, this is Frederick Williams for the extradition.
Okay. I haven't seen the paperwork on that. So if you can just have him have a seat just right where he's at. I need to get that paperwork emailed to me so I can look at it.
Yes, sir. Mr. Williams, just have a seat, sir.
Aaron, would you mind having somebody email that to Waynet? Because we haven't seen it.
I will do my best, Your Honor.
All right. Mr. Frederick will be with you in just a moment, sir.
Yes, sir. Evidently, so Mr. Williams needs to speak with the judge about an extradition. There's paperwork that the judge needs from over here. We all have that, but it can be emailed over the way in office. I would say to ask Ms. Silver, but I bet she's. I don't know, I'm not. We're gonna learn. Okay. Just let me know what you find out, please.
Yes, ma'am. I'm not going home today.
Not today. That's what I just told him. So. Are there any copies? Do y'all get the copies of that? Because those are for the judge. So there might be at least a template. We'll probably have to find this today. This is. I don't know why I just do that. All right. Okay, we're gonna start from scratch. Huh? We're gonna start from scratch. All right, thank you, Sylvia.